Chris will be presenting for us. Both of them have been advocates for a number of years. For those that don't know, Sharon, maybe she'll share a little bit about herself, but she actually came to us as an advocate from Harris County, was a CASA in Houston. I remember the first day she walked in the door and she walked out and I was just like, there's no way she's going to want to volunteer with our program. Because I just thought, why would you go from Harris County to Walker County? But here we are. Sharon's going to be sharing with us some of her expertise, and then Chris has been an advocate with our program now for 7 years, 7.5 years. And so he also has quite a bit of expertise, especially on local stuff and long cases and hard cases. And so they have a lot of good information to share. I'm going to turn it over to Sharon, present for an hour and a half or so. At around probably 5:30 or 6, we'll break, get some snacks, drinks, whatever, and then we will jump back into the second half of the in-service. There are waters and mints and candy back there. Please help yourself. In the kitchen, there are drinks in the fridge as always, sodas and waters in there as well if you want them cold. Please make yourselves at home, help yourselves to whatever. I think that's it. We'll do some announcements before the meal as well. All right, Sharon, they're all yours.
Okay. All right, you all noticed the reference to two old advocates. We're old, but we're also old advocates. So you'll also notice the reference here to a disclaimer. We're not experts. We don't pretend that what we're going to talk about today, we know all the answers, because we don't. You're all out there doing the same thing that we're doing, but what we're trying to do is put together some building blocks throughout this presentation. Janet wanted me to talk about some of the areas that I had experienced, the judicial system, being an attorney, an active attorney representing people, and also then talk about advocates. So for the first half of the presentation, I'm going to primarily deal with those areas. Then we're going to get into some best practices. Chris is going to do some presentation on some of the resources that he's had contact with, and we'll talk a little bit about PMC versus adoption. We're going to talk about your interactions with CASA and the department, residential treatments, therapeutic hospitals, psychiatric hospitals, and then we're going to have some slides on what we think are good strategies, good opportunities for you, and what we're asking is that this be an interchange. If you see something or we say something that you think they're off the wall, pipe up, tell us, what's your experience? What have you learned in the time that you've done this? So as we keep going through this, I'm going to start off with the judicial system. I was fortunate enough in my career to actually sit on the bench for a period of time, and there are a lot of kind of intricacies that I thought were important that we talk about, and I've got a handout for you that talks about the qualifications for being a judge in the state of Texas. So if you'll just kind of pass those around. As I've set up here, each one is very different. Each of the court systems, the primary court system, of course, that we work with are the project courts or the family courts. I don't know how many of you have come out of a courtroom after a hearing and said to yourselves, what in the world happened? Was that judge crazy or what? What in the world are they thinking? I walk out feeling that way, and I know that when I had hearings, I'm sure there were people that walked out of my courtroom and said the same thing. Are they nuts? No. Didn't they listen to what was said, etc.? So what we're going to talk about is that each court, like I said, is different, and you'll see on your handout. But there's a few key points that a lot of people just walking into a courtroom wouldn't know. And in order to be a judge, there's an election or an appointment, which means that that judgeship is a political judgeship. Okay, so they're there representing the public, but by the same token, they're governed by the government that seats them. And part of that comes down through the Supreme Court. The thing to remember is, because it's political, because it's elected or appointed, if a judge doesn't win an election, typically what happens is that all of his staff are gone. So an election for a Democrat or an election for a Republican means that the judge then typically seats those people to work in his court as a bailiff, as a sheriff. We always had a sheriff in the court. But the key factor is that those people can turn around in a minute. The other thing to remember is that that judge may never, ever have practiced family law, ever. They don't have to. So when I left the court in Ohio, I worked for a judge who had been a family law court judge for 30 years. Her position went up for election, and they elected an attorney who had no experience whatsoever in family law. So it makes our position even more important. As we begin to present our cases, in a lot of instances, we're educating that judge about what family law is and what needs to happen. And we do that by our evidence. So it's really a key factor. The other thing is that they are appointed or elected by age, residency. They have to be a resident of the county, a U.S. citizen. They have to be a lawyer or a judge. And then there's a term. And that term is what I was talking about when I said they come up for re-election. And the whole court system can change at that juncture. It depends on what the judge that's coming into that term decides who they want and who they're going to keep. So you see a lot of educating on a regular basis, a lot of changeover. And sometimes we go into it thinking, oh, these people know everything. No, they don't. They don't have all the keys. So it becomes part of our job and part of the prosecutor's job and everyone else to educate, to make sure that that judge knows what the evidence is and educate them about the law. A couple of things that happened to me when we talk about differences in courtrooms. In our courtrooms in Ohio, nobody ever stood. My family law courtrooms, we had a regular courtroom. I had a plaintiff and a defendant, and I had parties. And then if we called witnesses, we called them into the courtroom. Even in juvenile court, I represented some juveniles, and even in juvenile court, because there wasn't a lot of space, we all had chairs around the room. Now, you were probably kicking the guy across the way, but that was okay because you could sit. One of my first experiences when I came to Texas in Harris County, I had a 2.5-hour hearing in Harris County, and we all stood for that 2.5 hours. So I was thinking, I wanted to raise my hand and say, I'm old, can't I get a seat? But yeah, so a lot of differences in that. The other thing is that in Ohio, children's issues were never litigated, never. In our family court, we were all licensed mediators, and the kids were not considered what we called chattels, which means they weren't property. So consequently, we had a social service wing of the court, and for a while I directed that social service wing, and we did custody evaluations with families, a lot like we do. Go out, visit, talk to the schools, get all the information, gather it all together, and then we would make a recommendation to the court. Chances are that through the process, they would mediate out some kind of an agreement for the children. But the thing was that the thing never, ever, the issues on children went to a jury or even to a judge. Those issues were decided in the family court by mediation or agreement. So that was vastly different for me. The other thing was that when I came to Harris County, well, this is one of my faults, and I have to confess. I get very anxious when I'm in the courtroom about making sure I get my story out. You know, I want to talk. And so it's very difficult to restrain myself sometimes. So in Harris County, I was before one judge pretty repeatedly, and we had a real hot and heavy case. And it got so bad that when she came in, you know how when the judge takes the bench and the prosecutor says, okay, judge says, give me a summary of the case, they look to the caseworker, and the caseworker always gets to speak first. She would always say to me, give me a summary directly, because she knew that I knew the case. So I went from Harris County to being the first to speak and get my piece out and get everything updated to a judge down here in Walker County who said to me, it's not your turn to talk. My family thought that was hysterical because they were never able to shut me up. But it's just the difference of demeanor. It's the difference in decorum in each of the courtrooms. And you've got to know that, because I only took one time for him to slap my hand, and that was it. So I waited my turn, not patiently, but I did. So my suggestion is that if you're going into a new court, the supervisors know the courts very well, but it's always good to see how the judge interacts with everybody. So it's a good idea if you get a new case and you're going to a new court to kind of go in and get the lay of the land. I always go and observe just to know what the decorum is, and so you don't tick off the judge before you ever get started. So probably the most important thing that I can say about going into a courtroom is we all write reports. We all think that when we write that report and it goes to the court, that people read it. I mean, you would think that, right? You would think I'm spending 2 hours consolidating all my information and getting all that important stuff so that the judge sees it. But you cannot assume that the judge sees it, and I'll tell you why. In Ohio, I had a docket. My docket started 5 days a week at 8 o'clock in the morning. 4 days, I had 8 cases in a day. I had a case every hour. In between that, I was hearing domestic violence cases. We had emergency orders come in, and we had to hear those within 24 hours. So whoever was open or whoever maybe wasn't open, the sheriff that managed our dockets would come and say, you've got to hear this case. So 4 days out of the week, from 8 to 4, I had a docket. The 5th day, I had half a docket. Usually ran from 8 to 12. And then half of the day that I was given to write up all those 36 decisions that I had made in that week's time. So consequently, did I have time to read a lot of things? No, because many times, although they gave us an hour for lunch, many times we would run over in the morning hours and we wouldn't even have lunch, let alone time to read any of the paperwork or any of the dockets. And you know what our dockets are like. You know, on a day of court, it's pretty extensive. So you have to think that while you're standing in that courtroom, that judge doesn't know anything that you do. You have to figure that even if they've had time, because we did have a project attorney or a project judge in Harris County who would pull the report up while she was on the bench, and she would go through it. But it was kind of a cursory run through, so she didn't have a lot of time. So you have to assume that you don't want to walk out of that courtroom thinking, boy, I wish I'd have said that, because you only get one shot. Because then that judge is going to make a decision based on what she has before her. Okay? Lost my clicker. So, we have in Texas what we call the Texas Code of Judicial Conduct. And basically what it says is it has to be an independent, fair, and competent judiciary to uphold the views of the law and the governing bodies of the state of Texas. So, I do have a copy of this. It's only 13 pages, but I have a copy for everybody. And I'll point out some things on here. What the rules also say is that it's really good to have written canons. It's really good to have written laws. But the thing you have to remember as the judge when you're sitting on the bench, there's all kinds of ethical concerns that go hand in hand with the law. So it has to be also ethical. And here we really have the role of public trust, confidence in our legal system. Judge is the arbiter of facts and law for the visible symbol of the government. I had an experience in Harris County that I'm going to share with you because I kind of took a stand. Probably they could have just never called me again for a case, but we went before a judge and he had a reputation, and I had looked him up online, so I knew he had a reputation, but he was the meanest, most vile person I ever met in my life. He was nasty and condescending to his staff, to the attorneys, anybody who happened to be in the courtroom, so that you could just see on their faces a desire not to speak, because if you spoke, then you always had a response. So we had a case, and the case did not end well, and I told the supervisor at the CASA organization in Harris County, do not ever call me for a case in his court again. I won't go. I will not go and see someone exercise their authority in that manner. And I'll tell you what happened to him. He got ousted by the electorate. People didn't vote for him. People had read what he was like. People had seen the decisions and some of the decisions he'd made. And so he didn't get reelected. But also in that year, almost the whole bench for family law got ousted during the election. So, you know, people are watching and they're thinking, does this person really need to represent us? And they spoke, and so he was out. The expectation of a judge are itemized in canons, and they talk about integrity and independence. The big thing is that the judge needs to be seen to be making an independent decision, not based on a friendship, not based on somebody he's known, not based on anything that would bias him. It has to be an independent decision. Avoiding impropriety and the appearance of impropriety. I'm trying to think. If I'm sitting on the bench and a case comes before me, and I was an attorney in the law firm that is coming before the court, and I represented some of their clients in some form of litigation before the court, and the attorney for the other side comes in and starts raising, holy heck, well, you're obviously going to be biased. You practice with this law firm. The judge then can recuse themselves, and that's the thing to do. Even if what he did not impact this lawsuit, did not impact anything, and he could have made an impartial decision, it's the appearance of impropriety that rules. So what he should do is he should contact the Supreme Court and say, this is what's going on, this is the case, I'm going to recuse myself because I cannot appear to be impartial in that instance. You'll notice that in the canons, they talk about extrajudicial activities. So not only are they viewed while they're on the benches, but judges are viewed when they're out in the community. If they sit on boards, if they sit, any kind of activity. Every year, annually, a judge has to turn in a report to the Finance Committee of the Supreme Court, which outlines what their income was for the previous year. If they have any extracurricular activities, anything where they would be collecting money, they have to report that. There are real restrictions on being able to sit on the bench and also collect third-party monies. When I first took the seat, I was still just fading out my practice. And I represented the elderly in probate issues. If nobody had any family and they needed somebody to handle funds or whatever, I was doing that. And so I had to get special permission from the Supreme Court to continue until I could close out those estates. And then I had to report anything annually that I earned over and above my salary so that they could be sure that there was no conflict, anybody could view it as an impropriety at all. So political activity, that's really interesting because judges run for office, and a judge will be sitting. I sat with a judge who was running for office, and it's illegal for a judge to demand that their staff help them with their reelection. So there's all kinds of observations and all kinds of times where people are accusing through the Supreme Court, well, they use this person and they demanded that I go out there and I do this and I do that and I do parades, but can't do it. Legally, you can't. You can't force somebody to be politically active, and you have to be aware that your political activities are also viewed by the Supreme Court. So being a judge requires a lot of internal ethical considerations, both while the person is on the bench as well as when they're not on the bench. So now we know that they have rules. Now we know that there are expectations, there are canons that say what a judge can do. So who watches the judge? Who keeps an eye on the judge? Well, the judge has several people. We talked a little bit about the voters because we talked about that judge who was not, in my estimation, my personal opinion, was not really very socially appropriate, let's put it that way. And so the voters said, nope, he's out. The other most critical is there's a Court of Appeals and a Supreme Court that sit higher than any of our local courts where we appear. And really, any decision that's made by any of the judges that we have can go to the Court of Appeals. They can appeal. So the biggest thing is there is a record. And when you go up to the bench, the judge turns on that tape recorder and everything goes on the record as far as what's said, what evidence is given. And then the judge, she doesn't go back into her chambers for a termination hearing, let's say. For a termination hearing that goes on and they call their witnesses and everybody's on the witness stand, she has to come up with what she calls findings of fact and conclusions of law. So the decision has to reflect in the evidence and match to the law in order for the judge to be able to make a decision. So if you're in court and you're testifying and you think, oh no, somebody else will say that, or that's not really, what I should be saying, think about it again, because the evidence is on the record. And any evidence that's not on the record doesn't get considered. So it's really important that when you're going to court, you know what the goal is and you know what you need to testify to. Don't assume that the caseworker is going to do that testimony. I think Renee had a case, and shortly thereafter I had a case, that if our testimony had not been before the court, it would have taken a totally different turn than it did, because the caseworker did not testify and give the evidence that was going to be necessary to terminate the rights of that parent. So it's really vital, the information you give. Then the decisions go to the Court of Appeals. And when I got out of law school, or even before I was out of law school, I clerked for a judge in a Court of Common Pleas in Ohio. And that's a civil court and a criminal court. So we heard civil and criminal cases. After I was done clerking for him, it's natural for a judge to start with a new attorney to give him cases. They assign him cases. And his one proviso to me was, do not get me overturned. Because that, a judge who continually gets overturned, the Supreme Court sees that, the Court of Appeals sees that. He came from a long line of attorneys and judges. Dad was a judge, his brother was a judge, and he's a judge. So he says to me, don't get me overturned. It was a criminal appeal. It was a procedural issue, and first time out of the box, I got him overturned. I was walking down the hall in the courthouse, and I hear this voice behind me say, I thought I told you. And he was laughing. It was just a procedural issue. It was a question of allowing testimony or not allowing testimony, and I won in the Court of Appeals. So no judge really wants to be overturned. So if they've got the findings, if they've got the evidence there, and they can match that evidence to their conclusion of the law, they've got a lock. They don't want to have to come back up around and hear a case again because it went to the Court of Appeals or it went to the Supreme Court. The evidence wasn't there, it didn't match. So, the cases can come back, and they don't want that. The other thing is that there is an ability to file complaints with the State Commission on Judicial Conduct. The Commission on Judicial Conduct takes any complaint from anybody. So I was fortunate. I had two complaints to the Commission. Typically how they function is they take the complaint, they review it, they request the record, and then they send the complaint to the judge to respond. On my two complaints, I never knew they were filed. The Commission reviewed the record and said there's no basis for this complaint, and they dismissed both of them. The problem I had was that the one complaint was issued by a gentleman that had been in the court some time. Another judge had heard the case and denied him custody of his child. It came around on review, and I had to stop all visitation because he attacked his ex-wife when she came to pick the child up. So we gave him supervised visitation. Supervised visitation, he made the moves on the supervisor who was doing the supervising the visitation. So we had to terminate his visitation. The next thing that happened is that my courtroom was elevated up on the second floor of the courthouse, and down below was the street. And we hear this megaphone out front of the courthouse, and he's walking up and down the sidewalk underneath my courtroom, calling me, excuse me, a white maggot-faced bitch. So the sheriff said to me, we're going to go down and arrest him, and I said, no, that's what he wants. He wants that much attention. So for the whole afternoon, he was down there, and I was continuing to hold court, and we were hearing him. The bad thing was that he took it a step further, and he stalked us for 6 months. And so every day when we left the courthouse, he was sitting outside waiting for the two of us, and so we had to be escorted in and out of the courthouse. So sometimes being that out there in the public can be dangerous, it can be scary. So the judges don't always have it that easy. So, I have to finally tell you that the judge that I overturned ended up, he hated campaigning. He hated it in the worst way. He ended up being appointed to the federal court, which is an appointment for life. and he'll never have to go out and campaign again. And he was supported by both the Democrats and the Republicans. Highly unusual incident where the two parties come together and support a candidate for an office. But he had full support. Really, really good judge, really quality guy. So we're going to talk now a little bit about lawyers. And I'm going to ask you the same kind of questions. Have you ever walked out of a courtroom and said, why in the world could that guy defend that guy? Why in the world does that make sense to him to be in there defending that? You know, we obviously can see that they've done wrong, there are problems, whatever. So why? The other thing is, look at that attorney over there talking to that attorney, talking to that prosecutor. They must be friends. You know, they must be fixing this case. You know, there's something squirrely going on here. Nobody should be friends. Everybody should be, you know, animosity. But it was interesting to me when I pulled up this in the slides from one of the, I guess one of the codes, and attorney came up with the same place advocate did. And I thought, that really sent a message, because the attorney is an advocate. And who is the attorney an advocate for? He's an advocate for his client. Not mom, not dad, not the kid, not anybody. He's paid by his client, or the court pays when they appoint, to represent the interest of that person. Again, there are rules of professional conduct. Now, I was going to print the rules of professional conduct for attorneys, but versus 13 pages, there are 120 pages in this handout. So it tells you that there are a lot of concerns about representation by attorneys. I think the key issue has to be, I'm going to try and show you. Elaine taught me this trick. She didn't teach me how to get it to go up.
Hold on, keep it down. Just open it,
Ah, a mouse. Everybody's best friend. I just wanted to show you some of the topics. Confidentiality, of course, we all know what that is. Conflict of interest, former client, you have come before you, you obviously, you can't represent them. Each of the law firms, and you may know this, and if you do, just ignore me,